Hello and welcome to this presentation where we will be exploring some maxims of law and equity, which is something that we began to explore in the last presentation on equity law, where we talked a little bit about the maxims of equity and what they meant. But now in this presentation, it's my aim to discuss why you may want to start using maxims of both law and equity to your advantage, and also give you some examples of maxims that are useful depending on the area of law that you are dealing with. I think it's really important that we give maxims of law and equity a little bit of a spotlight moment because they actually really deserve it, to be honest, and I hope to show you why. So let's get started. You should hopefully be aware by now that I love to start with definitions, especially starting with the etymological root of words that we will be defining. So, when we look at the word maxim, we can see that it originates from the medieval Latin propositio maxima, which evolved to the French maxime, which both refer to something that is the largest or most important. So, when we are discussing maxims, it is quite useful to have in your head the idea that all that a maxim literally means is something which is most important. Okay, so if you can grasp the maxim and even memorize some, then you will be doing quite well, my friend. You'll be doing quite well. Okay, so now to take things one step further, the law definition of maxim. So I have two definitions that are quite awesome to demonstrate the value of maxims. The first one defines maxim as follows: an established principle or proposition, a principle of law universally admitted as being a correct statement of the law, or as agreeable to natural reason. Coke defines a maxim to be conclusion of reason. He says in another place, a maxim is a proposition to be of all men confessed and granted without proof, argument, or discourse. The next definition reads as follows: a traditional legal principle that has been frozen into a concise expression. Examples are possession is 9/10 of the law and let the buyer beware. So, hopefully, from these two definitions, you can see that maxims are actually very valuable, right? Seeing as they express principles of law that the law recognizes as true. They're also concise, so literally anyone, regardless of their education in law, can actually learn about these and begin to get a really good grasp of the key concepts of law and even more complicated ones as well in a really easy and short form. So, you may be wondering if you should be using maxims of law in your legal dealings. So, I'm here to show you some arguments both for and against, so you can get an idea of if maxims are right for you and even if they resonate with you as well, which is important. So, on the for side, we have the arguments that they are clear and concise. So, they express complex ideas put simply. They are traditional and consistent, so they reflect established principles, which are super important to grasp because principles are like first things first, right? If you understand the foundations very well, then it means that any further information that you build on top of that will have a really solid structure to rely on. So you are more likely to be able to understand more complex concepts much more easily. Then they support legal reasoning. So they can be useful to help in the interpretation of case or statute law. They can be used to strengthen your side if you are notifying someone of certain information or if you're claiming or defending a case, then they can really add depth and authority to points that you make. And lastly, specifically when looking at maxims of equity, this is, using these will automatically invoke the use of equity and fairness in your dealings, which who doesn't want that? Now, on the opposite side of things, the against side. So we can see that maxims can be considered ambiguous. So where they can be open to their own interpretation. Then there is the argument that they aren't actually legally binding. It's case or statute law that will be considered binding, not the maxim itself. Then they can be considered outdated, where some may no longer fit the modern legal systems that have evolved since the time that these maxims were first developed. Then we have that maxims may sometimes conflict with statute law, in which case they cannot override the statute by themselves. And lastly, the argument that they oversimplify legal issues that may actually be very complex, right? Reducing them down too much where more detailed legal reasoning is needed so that the issues can be fully explained. Now, you may think of me as being a bit biased here, but just hear me out. I actually think that all of the against side can actually be transformed to further support the use of maxims actually. We have to do, we just need to change our perspective and also the application of the maxims itself. So hear me out, okay? Hear me out. So you have the argument that they are ambiguous, which may be true, but the thing is, using maxims in a contextually relevant place in conjunction with your explanations, then the context will clearly preclude any misinterpretation, right? So, in a contextually appropriate place, a maxim cannot really be ambiguous. Next, the argument that they aren't legally binding when compared to case and statute law. So, this may be true, but our use of maxims is going to be more focused on the equity side of the law, where the strict legal rules sometimes do not provide solutions that we're after, right? So, yes, they may not be binding. However, when we use them from the side of equity, where we're using them to support our equitable reasonings and things like this, then this use coming from the side of equity actually does have the power to override statute, common law, case law, all of it. So it really does depend on how you utilize these maxims, right? Which is the key part. Next is the idea that they are outdated. Well, I would suggest that this actually shows us that the maxims have stood the test of time, right? Which means that they clearly have value to some degree. And what we can do is adapt them to the modern legal system instead of disregarding them completely. Then is the idea that they can conflict with statute and they cannot override the statute. Well, maxims weren't created to override statute, but actually to complement them, which is kind of the same idea as equity, right? Then the idea that they are an oversimplification, which again, this may be true, but maxims, they actually act as a foundation from which more details can be built upon. So, having already set the foundations in place means that, as I mentioned before, you're more likely to understand more complex topics with ease and be able to explain them with ease. So, I hope that this little exercise has shown you that maxims are actually quite valuable, especially when we discuss how you can actually apply them in your legal dealings in just a few moments. So, how can you actually use these maxims, you may be wondering? Well, they can be used in a variety of ways, such as in your legal writing, so in contracts or agreements you may be drafting. You can use these maxims to clarify your intent. You can use them in your legal arguments to strengthen your reasoning. And in statutory interpretation of words, there are certain situations where ambiguous wording can be used. So you can use them to strengthen your interpretation and to show others why your interpretation is best suited to the situation that you may be facing. In terms of litigation or in court settings, you can use them to support your arguments in your case. Whether you give these in writing or you speak them out loud at a hearing, they can be used to persuade the judge to agree with your side of things. And also, they can be particularly useful when you are seeking equitable remedies, since lots of the rules of equity are unwritten. Then you have the value of them when applied to an educational setting. So, they're really useful to illustrate legal principles in a very easy to digest way, which obviously helps a lot of people's understanding of more complex areas of the law, especially for people who are new to the law or they are returning to basic concepts to brush up on their knowledge. And lastly, in your everyday life and also business dealings. As so many maxims are based on ethics and conduct, they can actually be really useful in your everyday life and your business dealings. If you follow the essence of these maxims, then they can sometimes be really good guides of what you should or shouldn't do in certain situations. Really, essentially, so you can make sure to keep yourself out of trouble, really. So, now I would like to discuss some different maxims from a range of areas of the law, which I think may be useful for you to be aware of, and also to briefly cover what they mean, which some of them are quite self explanatory, really, but some of them not so much. So, let's get started. So, firstly, let's focus on contract law maxims. So, first we have the expression of one thing is the exclusion of another. So, this basically means when a contract or an agreement lists something that that contract will be applicable to, then anything that it has not mentioned is purposely excluded, right? So, an example of this is say you had a contract to sell two blue pens, two green pens, and I don't know, two red pens as well, then it means that the buyer wants specifically blue, green, and red pens, right? For a reason. And then the rest of the colors that you may have available, for example, orange or yellow, they've been excluded for a reason, right? Because they don't want those colors included. So I would use this maxim in situations where I've stated what my intentions are regarding my words and actions, and to state that the intentions that have been expressed for a reason, right? It is because I did not intend anything other than what I have said or done. The other options of what I could have said or could have done have been excluded purposefully on my part. Next, we have he who is silent is seen to consent. So, this refers to the idea that if someone gives you a contract, for example, and you accept the contract without contesting any of the terms, whether you actually sign it or not, or you just begin to act as if the contract is active and therefore enforceable, then it will be viewed by the law that you consented to all the terms. Because if you didn't, then you would have said something to the contrary right at the beginning when you had the chance. So, how would I use this? Well, this would be applicable in situations where you have stated some facts of a matter, for example, and if no one comes with you with contrary facts, then you can conclude that they've consented to your facts as being final and that they have nothing else to say against them, so that's the end of story. Next is fraud lurks in generalities. So, this simply refers to the idea that when we use language that we don't really specify its meaning, or we act in a way without giving any reasons for the act, then our words and our actions can become open to interpretation by others, where someone may interpret our words or our actions in a way that you never actually intended at all. And obviously, this can have negative consequences if it leads to, for example, misrepresentation or the misleading of others, which could be regarded as fraudulent activity on your part, which could get you in lots of trouble. So, I would use this maxim in situations where you are asking for someone to specify exactly what they mean or to give reason for their actions, or even for yourself when you use a certain term or act in a certain way that you know could be open to being misrepresented or misinterpreted by someone else, then why not avoid all these issues and come out right from the beginning with exactly what you meant so there's no room for errors? Then we have no one can act on behalf of another without authority. So, this really is the idea that everyone is responsible for themselves, right? And you cannot just decide to start doing things for other people if they never asked you to. So this kind of maxim I would use when maybe, for example, there's a third party to a contract trying to contact you on behalf of the party that you are contracted with. So this kind of maxim is good to use to kind of question this third party, to ask them where they're getting their authority to contact you. Or from your side, if someone is asking you to do something for them, you have to be mindful that you have some sort of proof that would be recognizable in law that you have done that because you have authority from that individual to act on their behalf. Otherwise, your actions may be voided altogether. Next is consent makes the law. So this refers to the idea that once a contract has been accepted by the parties and it's now lawfully enforceable and all of that, then the consent of the parties to become bound by that contract acts as the confirmation that the terms and conditions of the contract now act as the binding law between those parties. And also, in a general sense, in the UK, the government gets their authority to govern through the consent of the governed. So, again, the consent of the governed acts as the confirmation that the government has authority and power to make the law, which is like the terms and conditions of the social contract as such between the people and the government. Next is, no one is bound to do what is impossible. So this refers to basically any unfair contract terms. So for example, if there is a ridiculous contract term that is literally impossible physically for you to do, such as imagine there was a term that said you had to grow wings and fly 50 miles in 2 minutes. I mean, this is totally random, but anyway, it demonstrates what I'm trying to say. So clearly, it is physically impossible for you to do that because, well, you can't grow wings and you can't then fly. And even if you could, then to do 50 miles in 2 minutes is crazy, right? So you wouldn't be bound to such a ridiculous term. And if this was in a court setting, then a judge may even disregard that term of the contract completely or void the whole contract as a whole, if that's suitable. Then is a contract made under duress is void. So this is the idea that if you have been forced into an agreement under any sort of threat, then the contract is not valid or enforceable. Next is what is expressed renders what is implied silent. So this marries up with the first maxim, the expression of one thing is the exclusion of another. But there's a slight nuance here, which is that it refers to the idea that often lots of things go unspoken, right? And many things are based on assumptions and presumptions that we make, which lead us to implying certain things in certain situations. So this maxim is a good teacher to show us that it is actually best to express things clearly and specifically, because in doing so, you leave no room for anyone to come along and assume things about your words or your actions. Next is, the intention of the party is the soul of the instrument. So this refers to the idea that the way you write your legal paperwork will reveal your intentions behind your words and what you really meant to happen as a result of that paperwork that you created, right? Which links to the previous video on equity law, actually, where we discussed briefly about the 3 elements of jurisdiction that a court needs to have to be able to hear cases in equity. Specifically, the maxim that equity act in personam. So, regarding the authority over the person, whenever we get into conversations about intentions, we automatically know that this can only be in equity, right? Because equity acts on the person and also the conscience of that person. So anything to do with intentions should begin to raise alarm bells in your head that this refers to the equity side of the law. because equity acts in personam, and only people can have a conscience and intentions. And lastly, we have it matters not whether a revocation be by words or by acts. So, this maxim refers to the idea that if you're looking to remove your consent from something, which you can do at any time, right? There's no particular way that you have to do this. So, you can do it by words, so either written or spoken, but also you can show this by your acts, which is kind of in line with that famous saying that your actions speak louder than words, right? Now we move on to some equity law maxims. So, a few of these we have actually previously touched on in the previous presentation on equity law. So, I highly recommend that you check that one out before this video or you go back to it as a refresher afterwards. But some additional ones include where truth is, fiction of law does not exist. So, this refers to the idea that sometimes law will assume and presume certain things which will be regarded as true unless someone comes forward with the truth or the facts that would erase these assumptions and presumptions completely. Next is, let justice be done, though the heavens should fall. So, this refers to the essence of equity, that equity is really concerned with justice being done completely right. There has to be a complete solution to a problem. So, even though it may be the case that everything else falls apart in the pursuit of justice, then equity does not really concern itself with this because what matters is that justice is achieved at all costs. Next, a right cannot arise from a wrong. So, this comes from the idea that if you have harmed someone else, then you really have no standing to make claims against others that may wrong you in return, for example. This is especially important if you were the one who did the wrong first. So, the way I see it is kind of like if you just randomly punched someone in the face, then that someone punched you in the face in return because self defense is a thing, right? You can't exactly start running around screaming, being like, oh, the other person punched me, oh my gosh. Because, well, they wouldn't have done so if you hadn't started it first, right? Next is, he who seeks equity must do equity, and also equity will not aid a volunteer, which we already discussed this in the previous presentation on equity law, so definitely go check that out. Then we have equity will not allow a trust to fail for want of a trustee. So, this refers to the idea that in trust arrangements, if there exists a situation where a trust has no active trustee in office for whatever reason this may be, then equity will not allow that to be a reason why the whole trust arrangement is voided altogether. What would happen is that the court has discretion to appoint a new trustee whenever the situation requires it. Next is equity regards the beneficiary as the true owner. So, this reflects the notion that in the UK, trust arrangements do not have their own legal personality. So, in the US, for example, they can have their own separate legal identity from the trustees and the beneficiaries. But in the UK, that's not really the case. Instead, what happens is the trust will rely on the trustee's own legal personality to be able to own the property. So, this means that the trustee will own property in their own legal personality name on behalf of the trust. However, they are not considered the true owner of property, right? It will look like that at common law, but in equity is actually someone else, the beneficiary, that's actually the true owner of that property. So, next is fraud vitiates everything. So, this refers to the idea that if someone has acted in a dishonest way to gain property, then this would be considered as fraud, and this means that any transaction done under that act of fraud is voided. And in equity, there will be some sort of remedy for this. For example, there could be the imposition of a implied or resulting trust or a constructive trust by operation of law. Don't worry if this doesn't make much sense yet. Once we get more and more into trust law in the upcoming presentations, then things will become much more clearer and you'll begin to piece everything together quite clearly, hopefully. Next is where there is a right, there is a remedy. This refers to the idea that if someone has a right and that right is violated in some way, then there will be a remedy somehow, some way. And if the common law doesn't provide adequately, then equity will come along to patch things up, really. And lastly, we have equity rectifies errors. So, this is the idea that, again, within the law, there are often many assumptions and presumptions that everything has been done correctly. And the moment that someone identifies that something has not been done correctly, then equity will need to be invoked to go on to rectify those errors. So now on to maxims regarding evidence and ethics. So firstly, we have a presumption will stand good until the contrary is proved, which we have already touched upon, so this is pretty self-explanatory. If there is a presumption about you, then this presumption will be considered true up until the moment that you can provide contrary evidence that will discredit the presumption completely. Then is what is clearly apparent need not be proved, which makes sense, right? For example, if you have brown hair and brown eyes, then you do not need to prove this. They prove themselves by their mere existence. Next, the claimant is always bound to prove. The burden of proof lies on him. So this means that whoever is claiming something, they have to be able to prove it themselves. It's not going to be the one defending themselves, for example, that has to prove their side first. It's always the claimant who has to do this first. Then we have a judge's act that does not pertain to his office is of no force. So this refers to the fact that judges cannot do anything they want to, right? Just by virtue of their position, they are bound to codes of conduct and the law like anyone else. So if they act outside of this, then their act is not binding on anyone. Next is no one is above the laws, which links back to our first video on the introduction to law, where we discussed the rule of law, that no matter what position you hold, everyone is bound by the law at all levels. Next, all things are presumed to have been done lawfully until there is proof to the contrary, which links back to the maxim, a presumption will stand good until the contrary is proved. And this is why I say that it is presumed that everything has been done correctly, purely based on this maxim alone. And of course, it shows us that we have a lot of power if we can come in and prove that things have not been done lawfully in some way. And then, provided that you yourself haven't done anything wrong, then equity will come to help to solve any problem that there may be. Next is equals have no jurisdiction over each other. So if you recall from the equity law presentation, so jurisdiction refers to the legal power or authority of a court to hear and decide cases, right? But it also means the power and authority that one party can have over another. And this maxim gets at the notion that if no one is above the law, then this can only logically mean we are all equal under the law, and that therefore none of us really have power or authority over each other, right? This can only happen when we get into contracts or agreements where we end up voluntarily giving up this equality under the law pursuant to the certain terms and conditions, right? And it will be that if one party fails to do what they said they would, then the other party can come along and have jurisdiction over the other. It's because we are all equal, But then we get into contracts and agreements in which we voluntarily give up this equality if people mess up, right? Next is if you judge, understand. So this refers to the idea that you cannot really make a judgment on anything until you have been given the full picture of what actually happened first, and only then can you make some sort of judgment. So this applies to judges in court, right? So for them to make a judgment, they have to understand both sides to get a full picture of the matters at hand before them. Otherwise, the judgment that they make wouldn't really be a true reflection of the actual situation that they've been tasked with dealing with. Next is no one can sue at law in the name of another. So this refers to, for example, if you have a contract with one party, let's call them party X, and for some reason they are suing you for breach of contract. But when you look at the court papers, you actually notice that the claimant is actually party Y, who you have no idea who these people are because your contract was with party X, right? Then this maxim would be applicable because party Y wouldn't really have any legal standing to make any claims because they had no right in the first place. It was party X who had the right. So party X has to be the claimant. Of course, there may be a situation where maybe party X sold their right to party Y, which would then justify these actions. But in that case, then party Y would have to show some sort of proof that they have lawfully acquired the right to sue you instead of party X. So I hope this demonstrates the idea of this maxim clearly enough. And lastly is a good judge decides according to fairness and the good and prefers equity to strict law. So this is a kind of ethics-based maxim that shows that judges really should have a preference for equity instead of strictly following the law, as equity focuses on avoiding hardship, right? And this really should be their ultimate goal with whatever they're doing. So now we move on to maxims that have a focus on procedural matters. So first up is, no one is bound to accuse himself except before God. So this really refers to the right that you have to remain silent, right? To avoid saying anything that could possibly be taken as evidence which could be later used against you. Really, no one is bound to say anything if they don't want to. Next is, an act done against my will is not my act. So this links to the maxim of contract law that we spoke about earlier, that no one can act on behalf of another without authority. So what this maxim refers to is that no one can be forced to do something that they do not want to do. Of course, within certain limits. Obviously, if you haven't committed a wrong, if you've committed a wrong, then you may be forced to do things which you didn't want to do, but that's a different situation, right? If you haven't done anything wrong and someone is pressuring you to do something, for example, sign a contract or something like that, then because it is not your intention to do that act, if you did do that, maybe under the influence of threat or coercion, then this would void the act altogether. Also, imagine a situation where someone does something on your behalf or is stating that they will do something on your behalf, and you never ask them to do that, yet they go ahead and do it, then because you expressly stated that you didn't want them to do it in the first place, then that act will not be considered your act at all. In fact, it would be considered their act, and therefore any sort of liability that attaches to that act becomes the liability of that individual who decided to act on your behalf without your authority in the first place. Next is, may the other side be heard. So this refers to the idea of due process of law, which essentially means that everyone is entitled to fair treatment within the legal system, and also the protection of their fundamental rights. Some of these fundamental rights will include the right to be heard, the right to defend a claim against you, and also the right to face any accuser claimant that brings a case against you, which is what this maxim captures in a very simple statement. Next is power that is derived cannot be greater than that from which it is derived. So if you watched the first video of this series, so the Introduction to Law video, in the British Constitution section, we did touch on the three elements of the British Constitution, one of which is the sovereignty of Parliament, which means that they have the supreme authority to make and also end laws. I also briefly mentioned in that section that because Parliament get their authority to govern from the consent of the governed, then this can only mean that the sovereignty that Parliament has is actually borrowed from the individual sovereignty of each of the individual members who take part in that society, right? Well, one of the reasons I said this is because of this very maxim. If Parliament exists because individuals have voted for it to exist, then logically speaking, anything that Parliament can do is only because the individuals that voted for it can do the same things themselves as well, or they have the power to do that as well. It cannot in any way mean that Parliament have authority over the individual, because power that is derived cannot be greater than that from which it is derived. Next is ignorance of the law does not excuse. So this refers to the idea that we are all assumed to know the law. Therefore, if you do not follow the law and you say it's because you didn't know, then this actually is not an acceptable excuse, because you are expected to inform yourself of the law. Next is both sides must be heard, which of course is similar to may the other side be heard, which we have already discussed about in detail. Then following on is the ignorance of those things that anyone is bound to know does not excuse. So again, this links to the maxim, ignorance of the law does not excuse. So this is further support for this idea, so you can use these two together if you need to. Next is no one is bound to be punished for the crime or wrongdoing of another. So this refers to the idea that if someone has committed a wrong and you had no involvement at all and you haven't done anything wrong yourself, then you simply cannot be blamed or punished for the behavior of another. I mean, to me, this is very fair and very logical, right? You cannot be held responsible for the behavior of others. You can only be responsible for your own behavior at all times. Next is man, in brackets homo, is a term of nature. Person, in brackets persona, a term of civil law. So this maxim begins to show us that there are two versions of us when we interact within the legal system. What do I mean by this exactly? Well, the first section of this maxim, so man or homo, is a term of nature. So this refers to your physical existence in the natural world. Then the other section of this maxim says that person or persona is a term of civil law. So this refers to the use of the word person, which comes from the Latin word persona, which is the term used with reference to civil law. So the area of the law that refers to non-criminal disputes between private parties, such as contractual disputes, right? So it is said that man, or homo, being the term of nature, is where the duties of the state are owed to the man, because man has many unalienable rights, such as the right to life, for example, which the state cannot infringe upon. Then on the opposite side, there is the person, being the term of civil law, which is where the state issues liabilities to the person. So the person and the property of the person may be owed to the state should the state ever make a demand for it. So it is important to know that Man is the version of you which the state owes duties to, duties that have to align with the natural rights of man, such as life, as we discussed earlier, versus the version of you which is the person. Hence, we all have a legal personality to use within the legal system, which is the version of you that is actually artificial and owes duties and liabilities to the state. And lastly, an insane person is considered absent. So this refers to the idea that if you are considered unable to manage your own affairs, then there will need to be someone who comes along to manage your affairs on your behalf, which is justified because of your inability to do so yourself, which means that someone else would have to come and take responsibility for you, right? So this is when you see situations like bankruptcy, which is a process that occurs when someone is deemed to not be able to meet their obligations, so therefore lacking responsibility and maybe harming their creditors. This will mean that they will lose their right to manage their affairs altogether, and someone else, so a trustee in bankruptcy, will be appointed to come along and manage your affairs on your behalf, which will be appointed by a court. And the last set of maxims that we'll be going over is a bit of a random category. All of these are important to be aware of, but I don't really have a particular category that they fit into nicely. So first is, things captured by pirates or robbers do not change their ownership. So this refers to the idea that when something is stolen or someone is holding onto property that actually belongs to someone else, then this does not mean that the ownership of the property has transferred to the party who has stolen the property. Instead, in the at-law side of the law, the ownership rights still belong to the original owner. And in the equity side of the law, equity may attempt to remedy this situation by, for example, imposing a constructive trust, where the party who has stolen the property may be viewed as a constructive trustee, for example, acting for the benefit of the original owner as a beneficiary. Next is, dissimilar things ought not to be joined. So this maxim, I think, links really nicely to the previous maxim that we discussed, that man or homo is a term of nature and that person or persona is a term of civil law. So these link nicely because, well, natural man and then the construct of person used in the civil law are two different terms referring to two different entities. And therefore, because they are not the same, they are dissimilar, and therefore they should not be joined. In other words, as man is not a legal person, then man cannot act nor claim to be a legal person, as this would be wrong and would actually be a lie. It's also important to note here really quickly that when the word man is referred to in law, even he and things like this, it doesn't necessarily mean that the law is ignoring women as such. Man is considered a general neutral term as such, where it's actually used to refer to mankind as a whole, which does include both man and woman, as ultimately they are both a man of sorts, if that makes sense. Next, we have, he is an infant who, on account of defect of age, cannot speak for himself. So, what this term is referring to is if you are unable to speak for yourself, maybe you can't manage your own affairs, or even take responsibility for yourself, then you may be viewed as an infant or a child, even though you may naturally be the age of majority. I think this maxim is important to show us that we have to be mature and responsible individuals, where we have to learn as much as we can about the law and how to best manage our affairs when dealing with the law. Because if you don't take this responsibility upon yourself, say for example, you rely on others to speak for you, maybe through a lawyer or a solicitor, for example, then this will show evidence that may lead you to be viewed as an infant who cannot manage their own affairs, which would therefore justify someone else coming along to manage things for you. But of course, as we know, when you're unable to manage your own affairs, you become subjected to whoever does come along to manage them for you. So I use this maxim really to teach me that I have to take responsibility for myself, become a real self governing individual, so that I'm able to manage my own affairs for as long as I can to avoid situations where my actions or my words may be interpreted as me not being able to take responsibility for myself and therefore justifying someone else to come and act on my behalf in ways that maybe I never wanted and also maybe acting against my interests. Next is the laws of nature are unchangeable. So, this refers to the idea that your natural rights, such as the biggest one that I mentioned before, your right to life, this is natural and completely unchangeable. No one can change this. So, these natural rights are the principal rights from where all other rights come from. So, if these principal rights are unchangeable, and if they're violated in the first instance, then this is very serious and would obviously give you grounds for taking action to remedy any harm caused by any violation of these natural rights. Next is nothing is so opposite to consent as force and fear. So this refers back to how we have previously talked about contracts signed under coercion and threat, how these are avoided altogether. This is because it violates the element of consent which is needed to make a contract enforceable. So, this maxim shows us why that is. It's because force and fear are the opposite of consent. If force and fear have been used, then logically, consent cannot be present. Then, flowing from this, we have it is not law but servitude to be bound by what you have not consented to, which just solidifies this previous idea further. Then there is a thing is not considered to belong to anyone if it can be taken from him by chance, or in brackets, or occasion. So this maxim touches on the idea that if you are under the impression that you own something completely, but if there is ever a chance that it could actually be taken away from you, then logically speaking, this can only mean that you never owned it completely in the first place. You are under an illusion. There has to be someone else with an interest in the same property if at any moment they could come along and take the property away from you. So, this begins to hint at the existence of two or more entities having proprietary rights to the same property at the same time, which is only possible through the mechanism of a trust legal arrangement, which we will be showing you more and more about in the next set of videos. So, this will begin to make more sense slowly, don't worry. Next is we shall sell to no one, deny to no one, or delay to no one equity or justice. So this maxim actually is similar to the wording of the Magna Carta as well. And what this is essentially referring to is that justice and people's right to justice and the ability to seek justice is not to become a for-profit business structure, right? Because equity and justice should be freely available to those who need them to resolve disputes. Next is no example is the same for all purposes. So, this maxim refers to the idea that we are all unique, right? And we all have our own unique experiences, which will naturally come with our own unique disputes and problems that we will have to resolve. So, in law, we can use case law, so judgments that judges have already made in previous cases brought before them. We can use this case law to support our own cases, but this doesn't mean that if your case is similar to another, It doesn't automatically mean that a judge should follow exactly what has been done previously, right? Because not all cases are going to be the same. They may be similar, but they're not going to be the same because obviously the people are not the same. Therefore, we have to be particularly careful when we use case law in our legal work. We need to use them as illustrations of what should be done and the outcomes that you're after, for example. But we should always be clear that the case is being used to support our own cases and our own points to get the outcome that is unique to that case, which is what that case deserves, right? And lastly, we have an error that is not resisted is approved. So, this maxim refers to the notion that with humans, things can go wrong. Human error does exist, but can sometimes be missed and overlooked. So, in these times, we need to be particularly vigilant and pick up on these mistakes as much as possible to avoid these errors having a detrimental impact on us and maybe the outcomes that we're after as well. So, we have been through a huge range of maxims and briefly talked about each one so that you hopefully can get a better sense of what they mean. And you're also starting to begin to see how useful these maxims can be for you when you utilize them for your legal work, and also as short and concise rules for you to show you how you should be behaving in legal situations. So, what have we achieved with this presentation? Loads is the answer. We have been through so much. So let's take a look at what we've covered today. So we've looked at the etymological and law definitions of maxim. We've discussed the arguments for and against the use of maxims. We've then further challenged the argument against the use of maxims. We've discussed how maxims can be used, so in legal writing, for litigation, to support your points, for educational purposes, and also to guide your ethics and conduct. And we've discussed key maxims in different areas of the law. So this brings us to the end of this presentation on maxims of law and equity. My aim with this presentation was really to get you to start familiarizing yourself with the huge possibilities available to you when you study and utilize maxims of law and equity in all aspects of your life, really. I hope that you can see that despite them being short and concise statements, they can actually teach us a lot and get a lot of complex ideas across in a very simple way. They can also help you to start to see the strength and power of this knowledge when you apply them to specific situations, right? And they can really help to strengthen your case and all of your interactions with the legal system as well. So if you found this presentation helpful for you, helping you understand how you can use maxims for your benefit, then please leave a like, share it with someone who may also find this information useful, and also make sure to subscribe for more law educational videos that you will definitely get something of value from. Thank you for watching. I hope to see you again in the next presentation. Cheerio!